Deputy Solicitor General, we may be wrong in our understanding. Today, there is an interpretation of law by the Supreme Court. There is some degree of, we would say, arguments possible with regard to the ratio. What is the difference between a production warrant and a formal arrest? What do you mean by a formal arrest? Read 54. Let us read 54. Let us understand 54.
No, I've read it, but I've read
it aloud. You have not read it. Yes.
Well, I've got the certified copy. Now, there was never a prayer for shown arrest at the first point of time. The order which your lordship was seen.
Production warrant was issued.
Only.
That is enough.
But no, the prayer was only for production warrant.
So, you want to argue this, right?
Yes, madam.
All right, argue it.
Well, it seems your lordship is not receptive to my argument.
The Supreme Court is not receptive to your argument, not us.
Why not?
Because the Supreme Court says that if a production warrant has been issued,
could I see the judgment? I am not aware of it, but
judgment that you placed yesterday.
No, that I have got it, my lord.
Yes.
See the conclusion part, my lord.
Tell us.
Dhanraj. See, sir, my lord.
Yes.
Come to 60, my lord. Paragraph 61 onwards.
Please place it.
No, my lord. But I wouldn't know because if the production warrant was enough, then why should a prayer be made by CBI to show me arrested on the next day?
We don't.
But please seize the order. But please seize the prayer.
See the judgment first.
But it sees the production. Their prayer, my lord.
Let us see the judgment first. What does the law say? Please help us to understand the law. Conclusions.
My lord, one thing is sure, my lord, I think, my lord, if your lordship comes to page paragraph 54 first.
Yes.
Paragraph 54. Well, paper arrest will not allow me to be. I can have a right to apply for anticipatory bail.
Right. Till he is arrested by the police on the near formal arrest, not extinguishing. Yes. All right.
It doesn't matter. Well, the conclusion is paragraph 61. Sorry, 60 থেকে আরম্ভ 60 থেকে আরম্ভ তারা 60
Injustice can't keep both. Sometimes you play the key market.
Well, the first prayer of 25th, my lord. Please see the prayer of the IO, my lord. On 25th, the prayer of the IO, my lord, I've annexed it. My lord, page 9, my lord, page 9. Page 9, my lord. Humble petition filed by CBI in issuance of production warrant against Sujay Kishore Bhadra. That's 25th. Then, my lord, on 26th, the IO makes a prayer for shown arrest.
Yes, Mr. A. What do you mean by this prayer of shown arrest on 26th?
Well, we had already shown him arrest. As far as
They are
order is
asking
concerned.
you about your prayer of 26th.
My lord, I apologize. The first prayer, my lord, is the first application which was made on 25th. My lord is on. My lord, here the prayer portion, which I see, my lord, it is saying the production warrant.
Production warrant. Then what shown arrest?
My lord, in my respectful submission, my lord.
A shown arrest precedes production. A shown arrest precedes
My lord,
production
I
warrant.
bow down. I bow down.
So if you bow down, explain 26.
Well, what has happened is it is very much reflected from the order itself. The first order.
Mr. Trivedi, your officer is praying for shown arrest. Why? Why is he asking for shown arrest on 26th when an order of production warrant already on 25th? That means he's a sub-inspector of local police station. This is the confidence rested in the specialized agency by the High Court in a multi-crore teacher scam case. Who doesn't know the distinction between shown arrest, production warrant? Or is it some other sources which are influencing the wisdom of the officer?
No, my lord.
No, there are two options.
That's
Either ignorance, which betrays constitutional trust vested in the agency, or extrajudicial influence, which prompts the officer to forget what is the law. Tell us which one is there.
My lord, neither here nor there. My lord, inadvertence, my lord.
What inadvertence?
My lord,
This is inadvertence.
My lord,
this is inadvertence.
My lord, I cannot
who
say
is the public prosecutor who gave him opinion to make this prayer?
My lord,
who is the public prosecutor who gave the opinion to Wasim Akram Khan?
My lord,
Wasim Akram Khan must file an affidavit explaining why he asks for shown arrest after a production warrant is issued.
My lord, once again, may I?
Is he trying to assist the accused person?
My lord, it was.
Or your agency is doing a eye wash?
No, my lord, that is not that. Not if my lord so deems fit and proper.
Leave the accused if you don't want to arrest. Come clean breasted. Don't leave things to defect so that the accused can escape between the fingers of law. That's not the duty of a fair, decent agency.
I apologize, my lord, but this is a. I would not say. I will not go to the extent of saying it's a bona fide mistake. It is an inadvertent mistake which should not have been made, my lord.
Because so, take steps against this officer.
My lord.
Remove this officer.
My lord.
Remove this officer from the investigating agency. Let us see what you do as a employer.
My lord, he is a very good officer. My lord.
No, if he is a very good officer, why the reflection is not there?
If my lord will kindly see what
why he pays for you explain, Mr. Deputy Solicitor General. We may be wrong in our understanding. Today there is an interpretation of law by the Supreme Court. There is some degree of, we would say, arguments possible with regard to the ratio. What is the difference between a production warrant and a formal arrest? What do you mean by a formal arrest? What do you mean by enlighten us? What the paragraph 54 means? What is a formal arrest? Does it mean the physical communication? Then the line says that formal arrest precedes production warrant. Then in the interregnum, there can be
application for
anticipatory bail. But if the production warrant is already there, then how can a prayer for formal arrest be made? It is already subsumed in the prayer of production warrant. File your response to this.
It should have been worded in a different manner.
Would have been worded. What would be the wording? Tell us.
My lord, in my respectful submission,
what would be the wording?
What has fallen from my lord? That
what should be the wording? Tell us.
My lord,
you either take steps against an officer who makes this application, or we pass our opinion about the quality of investigation in this case.
My lord, will not be that harsh.
What can we do? We are asking you to be taking disciplinary steps. You are not taking. We have seen wonderful exercises of, we would say, delay in progress of proceedings. In one of these scam cases of which we had seen of bail application, we found how the state chief secretary is dragging his feet in not permitting a decision being taken about grant of sanction, and thereby in some way, inadvertently, as you will say, or otherwise assisting accused to get bail. You have no answer why a production warrant order prayed aloud gets muddled by a prayer on the next day for shown arrest. You file your affidavit. Let the officer file an affidavit of this. Why this exercise? What is this exercise all about? Affidavit petitioner?
No, in the interim, this should not become infructuous.
What infructuous?
The anticipated bail application.
You will have a bail application.
Well, then the whole thing
goes on.
Well, an entry press, small. Only
you want us, we will make it clear that this is an absolutely uncalled for application for showing him arrested. The formal arrest is precedes.
No, but
the desire to arrest is the formal arrest.
Well,
and the communication.
Till such time they file the affidavit, ballot. Only to that extent, ballot.
No way. This is either, as we made it very clear, we accept the Deputy Solicitor General submission that the formal arrest is inadvertent. That is the, I would say, least and the most charitable stance that we can take about this proceedings. What we would say, putting the hand of the clock back. Mr. Mukherjee, you are an experienced lawyer.
Don't embarrass me by saying all
An
this.
experienced lawyer. It's something like an
Don't embarrass
accused.
me. Don't embarrass me.
It's something like an accused praying for discharge after charge is framed. All right. What will the judge do?
Well, it's true. Well, it's true. Well, can't I take advantage? Can I take all my own records? I have come before your lordship.
The assistance of the Deputy Solicitor General.
Well, let the affidavit be filed.
Tell us, how do we read your prayer of 26 when the judge has already issued a production warrant? What is a production warrant? The man is not before me. You are wondering.
In another case.
So, in other words, the prayer for shown arrest is inferred in the prayer for
production,
or the formal arrest is informally communicated. Now, there need not be a subsequent communication.
Well, as I told your lordship yesterday, here two has another forum. So, the production warrant, because I have not been made an accused as yet.
Mr. Mukherjee, the limited area what we may ask you to answer is, does the ratio in
this thing, Dhanraj,
permit an anticipatory bail in the interregnum between the issuance
of the
and execution of production warrant?
Well, where is the bar here?
We are asking you.
No, I'm sorry. Well, I
from that and say, where is the bar? Apply your mind and address us.
Okay, I'll do that.
Because this paragraph doesn't say. It clearly says.
Well, it is, I'll be honest to your lordship, it can be going this side, that can go to that side. But the conclusion is 60, your lordship sees conclusion 60 and 61.
Tell us, where is the conclusion unequivocally saying that a production warrant not executed?
No, PTW, has not been said. That has not been said in so many terms, my lord. But your lordship is saying that if I've got your lordship correct, the prayer for shown arrest
police remand has not been passed. It is an offense. While being in custody in relation to will only be available to till he is arrested by the police officer on the strength of a production warrant obtained by him in the court.
Yes, that is what.
This line helps him. So if just production warrant is issued and it has not been communicated to the accused, we must clarify mere formal arrest on paper will not execute the right of the accused to apply for answer. We say so because a formal arrest would not result in the submission of the accused, who is in custody, to the custody of the police officer effecting a formal arrest. Yes. Mr.
A little ray of hope.
With respect and with folded hands, sir, please apply yourself and make an argument forensically. There is no ray of hope.
No, man, I'll tell you what you want, man. If I'm going by 54,
please read 54. Let us read 54. Let us understand 54.
No, I've read it, but I've read
it aloud. You have not read it.
No, man, for a change, I've read it.
No, if for a change you have read it, please you're reading with us.
Yes, madam. The option of applying for anticipatory bail in relation to an offence while being in custody in relation to a different offence will only be available to the accused till he is arrested by the police officer on the strength of the PT warrant obtained by him from the court concerned. We must clarify that mere formal arrest on paper arrest would not extinguish the right of the accused to apply for anticipatory bail. Well, here I join issue, my lord. Here is where I join issue, my lord. My right under 438 does not go away. We say so because a formal arrest would not result in the submission of the accused, who is already in custody, to the custody of the police officer. Effecting a formal arrest, the police officer on the strength of the same procures a PT warrant from the jurisdictional magistrate. The accused would have no other choice but to submit to that compulsion, and the accused right to apply for anticipatory bail
Now you see,
would get extinguished. Well, let them give an affidavit, man. Let them give why they made this to prayer. And even the learned court on 28th also, my lord, said, unless the production is there, there's no question of a arrest.
to apply for custody regulations. Contrary to the first line.
My lord, as your lordship, my lord, yesterday I read out, my lord, from 3 and 2, subsection 2. But there are two parts to it. Because this is all under 267, new 3 and 2.
Do you understand?
They waited. It is But while he was in custody in connection with the ECIR case, my lord, he was summoned as a witness. So conversion from a witness to an accused is what is happening. So, my lord, if your lordship sees A, that the person confined
Right.
President transfer warrant. Production warrant, petition. Petitioner transfer warrant.
In the facts of that case, there was no production warrant.
No PTW.
He was arrested in the penal code predicate offences. Then the ECR was registered.
Then he was
for anticipatory bail, relying on Saini.
Yes.
The judges overruled Saini and said no. He can always be taken into custody. He can always seek anticipatory.
Yes, that's the facts of the matter.
Now here what has happened is you have approached us at a time when the production warrant was issued, rightly, wrongly, and was communicated to you, served upon you. So the issuance of and now in that factual stating,
Yes.
stating,
Yes, my lord.
if you see the last line of paragraph 54, that
From the jurisdiction managed, the accused would have no other choice but to submit to that compulsion.
yes,
And the right of the accused to apply for antecedent redress is extinguished.
right,
Yes. But the fact remains, my lord, this will never serve upon me. In the sense that it is served on the officer in charge, then to
that is
bring
the
me.
sir.
No,
That is
that
the
to
sir.
get
That
to
is
pay.
the sir.
No, no, true. But well, there the arrest part was not there.
The production warrant itself, so it's
Well, according to your lordship,
if
production
after
warrant
taking a
involves
formal
shown arrest.
arrest,
That is what my lord is trying to say.
what is a formal or on paper arrest? That is shown arrest.
Yes, that is not been done.
So that
So I can apply for 438.
the production warrant has already been done, which infers a shown arrest.
But what the judge has said, that unless production is done, because he did not
That
take
is the
production from
judge's
virtue. So that is what I am saying, my lord.
That is a judge's erroneous understanding that is not going to confer jurisdiction on correct line to interpret the state of affairs.
No, true.
A state of affairs is a prayer for production warrant was made
On 25th.
which came to be allowed.
Yes.
It was communicated and served upon the
OC,
superintendent of the
yes,
correctional home, and therefore was in fact communicated to the accused, to your client.
My lord, if your lordship sees 3 and 4,
Situation.
my lord, if lordship sees 3 and 4 of the CRPC,
Correct.
the new book, my lord. 3 and 4.
Yes.
So my the production was never affected.
Production
So it was never affected. So the arrest part remains as it is. That is why we have come under 438 before lordships.
production was never affected.
Yeah, no, because this has been given by reason of so and so. What happens? The officer in charge of the order made by so and so under sections applies. The officer in charge shall abstain from carrying out the court's order and shall send to the court a
They
schedule.
must give reasons.
Yes,
They must give reasons. So ABC.
so
why.
yes, my lord, the last part. Well, let them give an affidavit, my lord.
Yeah, that we would.
315, man. 120.
Will come at 2 p.m. Yes, Mr. Trivedi.
Whatever falls back, my lord wants me to come at 2 p.m. We'll come.
I'm going to finish this an order of evidence. Affidavit.
For affidavit, what has fallen?
So you file your affidavit.
Yes.
Petitioner contents that the that he had not been shown arrested earlier. He had not been shown arrested in the instant case, and the production warrant issued on 25/11/24 has not been acted upon. Subsequent, no order has been passed on the no order was passed on the subsequent prayer to show arrest. Subsequent prayer for showing the petitioner arrested on 26/11/2024. In view of the ratio in Dhanraj Aswani, referring to paragraph 54 of Dhanraj Aswani, Mr. Mukherjee contends that the prayer for shown arrest, prayer for anticipatory bail is maintainable. We have Deputy Solicitor General seeks leave to file affidavit. Now we have looked into the materials on record. On 25th 11/2024, prayer was made.
Page 9. Page 9.
Prayer was made for issuing production warrant against the petitioner, against production warrant of against the petitioner, as substantial material has transpired against him in the scam
on RC6
in the scam relating to appointment to undeserving candidates in schools, aided schools, in various aided schools. The prayer came to be allowed on the same day. On the next day, the investigating officer prays that the petitioner be shown arrested, prayed for police custody.
Or both, my lord.
After
Both, my lord. May be kindly shown arrested.
Prayed that the petitioner be shown arrested and remanded to police custody. Learned judge observed, prayer for custody can only be passed after
Production.
the accused, after the petitioner is produced. Full stop. A prayer for production warrant of an accused to clarify the stance of the investigating agency, we call upon the investigating officer to submit affidavit to clarify the ordinarily a prayer for showing a person showing an accused arrested in a case precedes the prayer for production warrant. Full stop. Paragraph the prayers of the investigating agency requires to be seen in light of the observations of the apex court in paragraph 54 of Dhanraj Supra. Affidavit of the investigating officer. Investigating officer is directed to submit affidavit within 1 week.
Slightly more, maybe more than 1 week.
Within 2 weeks. Matter will appear 3 weeks hence. Reply if any 1 week.
Interview.
What interview? They will not do anything. They are waiting for you. Don't worry. Nothing will be done.
My lord, may I ask a personal question to Justice Kant with your lordship's person? Well, where do we get senior gowns in Delhi?
Observation. The prayer was for police remand. If you see it in that perspective, he has prayed for production warrant and then he has prayed for police remand. And the judges rightly said, first physically produce the accused or produce him through electronic means and then police remand. The shown arrest is more in the nature of a reference point. The question is, however, to understand the two observations in paragraph 54, the first line saying, till arrested upon production warrant being issued, he has a right. And the second line says, once formally arrested and production warrant is issued, there is no other option but to surrender. Correct? So these need to be reconciled in contextual and legal interpretation.
Grateful.